Hi everyone, my name is Yi. I'm your host for this episode. This is a bit of review for the exam, so I'm reviewing a few topics or learning objectives and domain 70. This particular episode is about domain 71.1, how laws arise and legal framework for workplace health. There are mainly 7 tiers of law. We start with tier one is constitution. That is instrument is Australian constitution. Its supreme law has the legal force. The next step is that primary legislation. They are usually acts of parliament. They have full statutory force and create offences and duties. The third is that subordinate legislation. You can see them as regulations. They still have statutory force, and it depends on how individual act applies. Executive, usually Governor General or Governor, can make such changes and the authority of the act, and followed by legislative instruments such as rules, determinations, and orders, and they are made by minister, secretary, or delegated official. And the fifth tier is approved code of practice that cover code of practices. They are not themselves law, but admissible in court as evidence of what is reasonably practicable. And then we have standards, which are Australian standards, AAT NCS joint standards. They are not admissible and don't have any legal power, certainly voluntary, but they could be called up in a legislation or code of practice, and which makes content or statement on the standard has legal power. And the seventh step is guidelines or guidance notes. They do not have legal force and they are advisory only. However, both standards and guidance provide us as what could be best practice, and they can form usually the floor rather than the ceiling of what is the reasonable and safe medicine practice. The next step is we also need to know what is difference between common law and statute law. So common law is made by judicial decisions, case law, and statute law is by parliament and executives. So judges decide cases and precedent builds over time is common law, whereas the statute law is passed by bill, act, and royal assent. So common law is evolved incrementally through new cases, but to make any changes to statute law that require formal amendment by parliament. Common laws are used for civil actions such as damages and injunctions, whereas statute laws are in use in criminal prosecution, administrative notices, and civil penalties. To give an example, is that common law is that usually negligence action by the employer causing health and safety incident and due to their breach of duty of care. And statute law is that they are not practicing the work health and safety regulation that they require. Other laws such as criminal law, contract law, or tort laws are not directly relevant to an OP. When we are looking at Work Health and Safety Act, so each state follow the Work Health and Safety Act, and except Victoria. So Victoria retained Occupational Health and Safety Act 2004 and Occupational Health and Safety Regulation 2017, whereas the others use along the similar line with the rest of the country. So this is not a big area that we need to know, or at least I think we need to know for the exam point of view. I will revise again. Laws arise through parliament and executive. Common laws arise through judicial decisions. A hierarchy is that we start with constitution, acts, regulation, legislative instrument, code of practice, standard, guidelines. Legal enforceability decrease down the hierarchy. approved code of practice are not law but are admissible in court as evidence of what is reasonably practicable. Australian standards are voluntary unless called up in the legislation or code of practice. When the law is unclear, general duty, so far as reasonable as practicable, must be applied, and the reasonably practical test S18 applies. So that is applicable in workplace situation where there is no specific legislative requirement or standard to meet, but you also need to make sure the worker is fit and safe to perform the role. Well, that's domain 7.1.1. And then I will jump to domain 7, sorry, not 7, 70, 72.1, industry relation and their influence on health and safety. So an occupational physician, or at least in the stage B, has knowledge of local IR mechanism and their documented effects on health and safety. And we need to able to tell or discern the difference between physiological basis of an industrial agreement from scientific evidence. Industrial relation, the main law we need to know is Fair Work Act 2009, which is Commonwealth. They are the primary federal legislation. It establishes our national workforce relations system covering most private sector employees, and any dispute will go to Fair Work Commission and Fair Work Ombudsman. So it sets our national employment standard, which has 11 minimum entitlements, such as the weekly hours, leave, and notice of termination to provide a framework for modern awards and enterprise agreement. So industry instruments are the modification, so it includes modern awards, which allows the industry or occupation specific minimum conditions, and that may include health and safety relevant provision such as work hours, overtime caps, break entitlements, and shift penalties. Another type is the enterprise agreement. They're usually negotiated between employer and employees, often with the union involvement. They must pass the Better Off Overall Test, BOOT, and they cannot undercut the award, which is the basic level, and they have to be approved by Fair Work Ombudsman. Again, they don't really affect the health and safety directly, but they can influence work hours, fatigue management, policy on handling particular hazards such as heat or cold, PPE standard, drug and alcohol testing, and consultation mechanism with workers, dispute resolution, and return to work provisions. And on top of these two, there may be individual flexibility arrangements may exist. So general process to get into enterprise agreement, which has tend to have expiry date, is the employer notify employee, start with that, and then there are good faith bargaining between the two parties, and they negotiate and they vote. Usually the employee, and then they need FW, which is the Fair Work Commission, and they have nominal expiry, typically 3 to 4 years, and it continue to operate until replaced or terminated. As an occupational health practitioner, we must be able to discern the physiological basis of the agreement terms from overlays of industrial negotiation. Key industrial relationship mechanisms may include worker consultation and representation, so having the right to elect health and safety representative, since this is unpaid role, forming health and safety committee, and having union delegates and officials in the workplace. Having them, the idea is to have better hazard identification and greater worker engagement in the safety and controls of the. There is another thing called right of entry. So permit holder, usually union officials, may enter workplaces to investigate suspected Fair Work Act or OHS issues. There is also general protection. So it is unlawful to take adverse action against a worker for exercising a workplace right, such as raising health and safety concern, making a complaint, or participating in health and safety activity. So that means an employee cannot be sacked or terminated because employer doesn't agree with them. There is unfair dismissal dismissal that is harsh, unjust, or unreasonable. And workers have right to cease and save work. So workers may cease work if reasonable concern about serious risk of harm. Now that must not be reasonable management action in the context of psychosocial hazards. So these are common or key industrial relationship mechanics. I will go again. So worker consultation and representation, right of entry, general protection, and fair dismissal, and right to cease and save work. So at the end, the workers have right to have industrial action, which is protected by the law. So what are the benefit of having these sort of industrial relationship on health and safety? And we can think about like hundreds of years ago, where workers were sent into the mine with minimum safety standard, PPE, or regard for their well-being. So compared to that time, we move, we advance so far ahead for that, and that is the idea in the behind. So having that is that positive influence as well as negative influence. The enterprise agreement may not necessarily looking at the safety as a first priority. So things like shift penalty might be more prioritized over actually avoiding the long shifts, and then they may allow or not restrict on the consecutive night shifts. So that is good. Having the IR would allow formal consultation mechanisms, and it protects the employees from reprisal due to general protection. So IR mechanism allow dispute resolution procedures and support in the time of need. And in some of the industry, they may also help with return to work provisions. So these are positive things of having industrial relation. Negative influence is that the industrial overlay may distort the evidence, so such as overtime caps or penalty rates. They were negotiated instead of the safety, and they may not be aligning with the physiological risk. Sometimes they create adversarial dynamics and difficult to negotiate or get to agreement to get things done. And safety issues could be weaponized or used as a political bargain leverage. They may be resistant to health program, especially drug and alcohol testing, health monitoring, or use of certain safety equipment when there is distrust between parties involved. Unfortunately, many employees choose to go towards casual labor hire or gig work due to the many circumstances, and that create precarious work situation, and that reduce IR protections, and they may not be covered by standard industrial relation actions. So, what do we need to know? Well, we need, as an occupational health professionals, need to be able to identify where the industrial relationship and health and safety intersect. And we also need to know that the employee agreement or the advocated program may have both evidence base and there is industrial negotiation overlay. Regardless, our role is to provide evidence based advice independent from other parties. So that's important to know. So the next domain is 70.3.1. So this is about courts and their procedure. There are generally three categories of offense under this process. Category one is reckless conduct. So that include duty holder recklessly exposing individual to a risk of death or serious injury, and that require actual awareness of the risk and conscious disregard. So the key elements are that they know the risk and the hazard, and there is that the unjustifiable taking of that risk. Penalty is that imprisonment and high fines. Corporations have higher tier financial penalties. Category 2 is that failure exposing to the risk of death or serious harm. So it is failure to comply with WHS duty that expose a person to risk of death or serious injury or illness. There is no requirement to prove recklessness. So that also slightly lower, and there is substantial fine, and there is no imprisonment involved. Category 3 is failure to comply with work health and safety duty, and this is the least serious. So there is certainly breach of WHS duty without necessarily exposing an individual or people to serious risk, and there is fine. So from the occupational medicine perspective, category 1 offenses are linked to gross systematic failures, and that may involve forensic review, expert testimony. Category 2 in serious near miss or exposure cases. So that is for the risk assessment, documentation, and control adequacy need to be checked. Category 3 is might be an exposure related to systems, documentation, and gaps in surveillance that may involve audits and regulatory inspections. So these learning objectives are not directly asked, but they sit behind this thinking process, knowing whether a candidate knows how to navigate within the industrial setting. In Australia, the hierarchy of courts, of course, in the federal level, High Court of Australia, Federal Court of Australia, Federal Circuit, and Family Court. The last one may not be directly relevant to us. And then in each state, there is Supreme Court, highest in the state court, and there is a district or county court, followed by magistrate and local court. There is also specific specialist tribunals involved. It can be Workers' Compensation Commission, Fair Work Commission, medical panels, which is in Victoria, or colonial courts. A common scenario that we may need to compare is that what is the claim between workers' compensation claim versus common law claim? The worker compensation is that no fault statutory scheme, whereas common law is based on fault and must prove negligence. And we look at the causative threshold is that significant contribution to the injury in the workers' compensation, whereas in the common law, the employer's negligence must cause the injury. And the benefit is that workers' compensation will cover for the wage loss, medical expenses, and lump sum payment for permanent impairment. The common law also cover, it is not capped, damages for pain and suffering from past and future economic loss and medical expenses. Worker compensation obviously is generally available to all workers without needing to prove the fault, so any type of injury or condition that are arising while performing the work. Whereas common law is that must establish duty of care, breach, causation, and damage. The other part I included in my note is that type of witness. So expert witness is that primary duty is to the court and not to the party who engaged the expert, and must provide an objective, impartial opinion within the area of expertise, and cannot be act like an advocate for either party, and need to disclose all the material considered, including the material that may not support the opinion. Expert witness must identify assumption made and state if opinion is provisional. It means how certain is your opinion is. Obviously, there are rules bound, need to follow, and when undertaking a report, need to prepare according to the rule. And if a document is provided, expert must have made all appropriate inquiries and must state the question that they were asked to address. Need to distinguish between facts, assumptions, and opinions. And need to know the area of expertise and state within that area of expertise. Along the way are the IME, independent medical. I don't know why that is here, but let's go over it. Independent medical examination is not a treating doctor assessment. It is an independent, usually one of assessment of a worker, and consider all the relevant prior facts and clinical information, and should be an expert opinion as objective as possible. There is no doctor-patient relationship, not advocating for any parties, and not influenced by the desires of the referring party. And what are the responsibility to the patient? The IME must conduct assessment with respect and dignity. I see a friend about the independent nature. No treatment advice will be given. Do you explain the context of the referral and who make the engagement, and explain to whom the report will be addressed and what will contain. Need to provide information on the specialty and expertise, and have to gain consent to continue based on that. The assessment must be the professional standards but proper care. So if the outcome of the decision is not agreed by either the employer or employee, they can go on to further dispute resolution, which is called alternate dispute resolution ADR. That may include conciliation or mediation, common first step in workers' compensation dispute, and fair work commission matters. They are not binding. And the second is arbitration, and that's someone involved. The Fair Work Commission arbitrates the unfair dismissal claims, and some worker compensations duties have also arbitral jurisdiction. The third is the expert determination, where the parties agree to accept that an expert's opinion as binding. I think that's all I have under that. Learning objectives. Advantage of having that alternative dispute resolution, and that may include cost and time efficiency, usually faster and significantly less expensive than a full trial, reducing the financial and emotional burden on the injured worker. There is confidentiality and preservation relationship. So ADR proceedings are private, unlike open court. So there is a less adversarial process, can preserve working relationship, and also reduce the psychosocial or psychological harm of protracted litigation. Another note I included in my study is that regulatory enforcement options. So there are four types. Five. Let's start with the first one is the improvement notice. An improvement notice is that an inspector issued by an inspector if they reasonably believe a person is contravening a provision of Work Health and Safety Act or regulation, or has contravened a provision and the contraventions are likely continue to be repeated. The improvement notice specifies the contravention. For example, failure to provide health monitoring and require the person to remedy the contravention within a specific time frame. So to fix a situation within a time, and they specify if you don't do it, something will happen. So that is called improvement notice. Prohibition notice is that if there is an inspector belief that there is an activity is occurring or may occur at a workplace that involve or will involve a serious risk to the health and safety of the person, and it may cause immediate or imminent exposure to hazard. So usually involving stopping the activity immediately makes sense, and it takes effect immediately, no compliance period, and remain in force until the inspector is satisfied that the risk has been remedied. An example would be that if there are signs of harm due to use of organophosphate spraying operations, then the safe work or work safe inspector may advise them to give the prohibition notice, which need to for the business to stop immediately until adequate health monitoring, exposure control, and PPE provisions are in place. And therefore, the prohibition notice is the most powerful immediate enforcement tool. The third is that infringement notice or on the spot fine. So that's on parking or speed ticket. The regulator may issue an infringement notice for prescribed offenses. They are essentially on the spot fine for less serious regulatory breaches. Makes sense? Okay, that's good. I mentioned about expert witness before, and there is also another witness, which is witness of fact, treating doctor. Usually, patients treating clinician providing evidence on factual first-hand information obtained during treatment. Their role is to describe what happened, what they had to observe, and the treatment they provided. The scope is restricted to factual information about the patient's condition, injury, diagnosis, and prognosis. They have an ethical obligation to assist by providing factual records, often under patient consent or subpoena, but they are not obligated to provide expert opinions. They are limited to, or they should avoid providing opinion evidence such as assessing negligence or causation, and focus on documenting their findings, such as physical examination results and test results. Another note I've written here is this is not necessarily law, but legal definition. Inherent requirements. Inherent requirements of a role are essential duties or characteristics that are intrinsic to the position. The things or the tasks that define what a job fundamentally and is opposed to peripheral task or the particular way an employer happens to have arranged the work. The concept is central to both anti-discrimination law and fitness or work assessment. So it is included in the Fair Work Act 2009, Commonwealth General Protections, and also Disability Discrimination Framework. What makes a requirement inherent? It has to be essential, not incidental feature of the role. It is assessed against the substantive position, not the specific manner of performance the employer prefers. It can include the capacity to perform the work safely, relevant where the condition creates a risk to the worker or third parties. So if it is safety critical task, even though you can do A, B, C, D well, and you cannot do E, and that issue would create safety problem to other people or the worker themselves, this is not able to do inherent requirement of the role. It is considered after accounting for reasonable adjustment, a requirement which means that inherent requirement of the role is considered and it may include even reasonable adjustment. A requirement isn't defeated simply because the worker needs some accommodation, but nor can employer inflate the non-essential task into inherent one. So, what is a reasonable or what are reasonable adjustment? Reasonable adjustments are modifications to a job, a workplace, or the way work is done that enables a person with a disability or injury to perform the inherent requirements of their role, provided that the adjustment doesn't impose unjustifiable hardship to the employer. The legal basis is that this sit in the Disability Discrimination Act 1994. Well, that's all that is, I hope, in this. Hope you find this useful. Bye.